Say that trial is really made or broken when you call the jury and you decide those 12 jurors. But these hearings here seem to be incredibly important ahead of trial. And the fact that they're going to last several days, calling 28 witnesses, is this unusual?
It is very unusual for this to be so involved, the 28 witnesses. Multiple days for a suppression motion is more unusual, maybe 1, 2, maybe 3 days at the most. So this is very unusual, but the defense really has a good argument in terms of suppressing everything. So if they win, they would basically be able to suppress all evidence, or the most important evidence that the prosecution has. So it's the backpack, but everything that was found in the backpack, the alleged pistol, ghost gun, the notebook, which some are calling a manifesto, electronic devices, basically everything would be suppressed, and the prosecution's case would be very, very extremely weakened if the defense were successful here.
Do you need a search warrant when you are arresting someone you believe to have crossed state lines, had committed a felony like murder here, to search this backpack? And did police, in your estimation, do things improperly?
It's actually a close call. Normally speaking, suppression motions don't win. So if people are out there worried, I don't think that the judge will end up suppressing it, but they're going to have to make new law or rely on very thin legal grounds to avoid ruling for the defense. So your question was, can you search someone incident to arrest? And you can if you have probable cause to arrest. But here, it's an interesting legal issue, because how do they have probable cause to arrest without what they found in the backpack? The 3D printed ghost gun, the manifesto or journal, the electronic devices. So really, what I think the issue boils down to is, were the officers' comparison of the be on the lookout photos that were sent out via from the surveillance footage to the officers, was their identification of Mr. Mangione in the restaurant reasonable based on what they saw? Do they have the qualifications to make that ID witness? If they can compare the photo to how he looked and say, look, I knew that was a guy, here's why, then they can search incident to arrest, and they do not need a warrant.
To articulate probable cause, I mean, this is how you make arrests in this country. You must articulate probable cause, and therefore you can arrest, and then you bring before a judge who determines whether or not these charges are rightful based on the affidavit, a sworn statement from a police officer articulating that in their reasonable judgment they had probable cause to make this arrest. This was a manhunt across the country that ended in Altoona, Pennsylvania, with a call from someone at that McDonald's saying, I think Luigi Mangione is here. And from what I recall from that day, they interviewed him right there at the restaurant, and he presented fake ID, wasn't his name. And you would think that in the affidavit there would be enough reasonable cause to make the arrest in that moment. I guess the bigger question here is, does that probable cause not transfer to the backpack?
So the legal issue is that the backpack was moved about 6 feet from him at the time of the search, and there were officers in between him. So that kind of removes exigent circumstances exception. So then we are down to, which, if an officer says, look, I thought there was a danger to the public, I thought he could reach in that backpack and get a gun, so we searched it to make sure that it was safe. They don't have that here, arguably, because it was separated from him and there were officers in between it. So then we're down to what you just laid out. Can they say, look, we saw him, we knew it was him, there were other reasons why we reasonably believed it to be him that we can articulate to a judge to justify a search incident to arrest? Because without a warrant, you need an exception. And search incident to arrest is what I believe the prosecution will end up relying on. But let's not forget, it's in addition to the backpack, they're trying to suppress his statements, which the defense is arguing were made in violation of Miranda.
Yeah. Well, obviously, a defendant has a right to remain silent because anything they say can or will be used against them in a courtroom of law. So we know that to be true. The only question that I have here, Joseph, and I don't know if you know the answer to this, do we know